Daniel Bogdan mentioned that he had a conversation with Deputy Attorney General Paul McNulty regarding his termination, in which Mr. McNulty told him that the decision had come from higher up. To whom would Mr. McNulty, as Deputy Attorney General, have been referring?
Well, the decision was clearly mine, Congresswoman. It was my decision. I'm accountable and I accept responsibility for these decisions.
Okay. And in his that Mr. McNulty told him that he had, quote, limited input, end quote, in the final decision process to terminate the U.S. attorneys. Did you understand that the Deputy Attorney General had only, quote unquote, limited input?
It was
my understanding.
It was my understanding or belief that Mr. Sampson was consulting with the senior leadership, including and in particular the Deputy Attorney General, because the Deputy Attorney General is the direct report for these U.S. attorneys, including Mr. Bogdan. But at the end of the day, no matter the level of consultation, what I know is that Mr. McNulty, the Deputy Attorney General, signed off on these names. And in fact, on the day of Mr. Sampson's testimony, I went to the Deputy Attorney General. I said, "Do you still stand behind these recommendations?" And he told me yes. And
okay. Well, then who, to your knowledge, if the Deputy Attorney General had only limited input and that doesn't seem to trouble you, who, to your knowledge, had more than merely limited input in the final decision process?
Well, again,
was that on your shoulders? Is that you?
Again, Congressman, you probably have more information about that than I.
In his written responses to question from the Subcommittee on Commercial and Administrative Law, Mr. Bogdan mentioned that Acting Associate Attorney General William Mercer explained to him that the administration had a short 2-year window of opportunity to place an individual into his U.S. attorney position in order to enhance that individual's resume for either future political or federal bench positions. Do you believe that the office of the U.S. attorney is merely a vehicle through which to provide party loyalists with an opportunity to pad their resume and then use that as a launching pad for elective office or a judgeship?
As head of the department, I would say no, but there would be nothing improper in doing so.